Good afternoon. My name is Adil Patel and I am a director in the Employment Department of Cliff Decker Hofmeyr. Welcome to one of our quarterly seminars. You may see that I'm dressed in my running gear. This is what work from home does. No, and the firm has not yet retrenched me. As a matter of introduction, and as is customary with matters of this nature, give you some sort of highlights of what you can expect from the employment department. One is, for the next 4 months, we are going to be running a series of these workshops or seminars with various speakers. In September 2020, we will be having our annual case law update. And unlike the past, sadly, we will not have the privilege to physically see you and give you our free food and alcohol, but certainly we will have the seminar and you will get a registration form. And what emanates from there is, in our 7th year going, we will publish our case law update for all attendees for 2020, and those are our contribution towards empowering our clients, so there'll be no cost to register for that. As further as part of our development to empowering our clients and to ensure compliance, we've now moved on to assisting our clients with an e-learning model. So we have an e-learning model for a return to work from the purposes of COVID-19. And then, despite the fact that we're all working remotely, sexual harassment and harassment generally still presents a particular problem within South African society. And we have that e-learning product. If you'd like to inquire more about that, our colleague Riola, whose details can be found on the website and on your invites as well, will be available to engage with you on that. So today, my colleagues Thabang, Hugo, and Gillian are going to take you through what retrenchments in the time of COVID-19. We're all COVIDed out in relation to TERS, whether you're obliged to pay people, what is going to happen, whether TERS will be extended after June, whether Gauteng has now overtaken Western Cape as the epicenter. But what is becoming a hot topic now is the retrenchments, and this period is now becoming called the retrenchment season. Our next month, you'll see that we will talk about this again. There's a projected recession. There's a reduction in our GDP. Unemployment has rose to 30% and expected to possibly rise to 50%. And National Treasury estimates at least 2 million people could lose their jobs. These are just simply statistics that are made available to our colleagues. The problem is that when you're sitting with a business and you're unable to produce for your shareholders as a result of the downturn in the economy and COVID-19, how do you navigate this? I will now stop talking and hand you over to one of my colleagues who will now take you through the legal process and the challenges you are going to face when embarking on this retrenchment process. Thank you for joining us. I hope you have a wonderful time. Please feel free to ask us as many questions as possible. You will see that you are able to do so through engaging with us through a Q&A, and I will facilitate those either through interjecting one of the speakers or towards the end of each speaker or the session. Thank you and good afternoon.
Thank you, Adil, for that introduction. As Adil has already pointed out, retrenchments have become our reality and large-scale retrenchments are the order of the day for many employers currently. Large-scale retrenchment processes are regulated by Section 189, subsection 3, and Section 189, capital A of the Labour Relations Act. The large-scale retrenchment process envisages a consultation of 60 days. However, the timing of the retrenchment, the actual retrenchment, differs where there is a facilitator and where there is no facilitator appointed. An employer may terminate after 30 days if the process was not one where a facilitator has been appointed. Where a facilitator has been appointed, an employer may only terminate after 60 days, unless the parties involved in the facilitation process consent to a shorter period. We generally advise facilitation in a large-scale retrenchment process. This is to ensure a procedural fairness and to obviously mitigate against the risk of a referral to the Labour Court in terms of Section 189, capital A, subsection 13. During my section of this presentation, we will discuss the following topics: the role of a facilitator, new developments in law, particularly on timing of the voluntary severance packages and proposing VSPs where an employer has fallen on hard times. We'll also look at the issue of business rescue insofar as it relates to that particular topic. And we will look at options if an employer cannot afford severance packages. Now, moving to the next slide, we're now looking at the role of a facilitator. The role of the facilitator is primarily to facilitate the meeting and to assist the parties to reach agreement on the procedure to be followed during the facilitation. The information to also help the parties on the information to be disclosed by the employer. The facilitator will chair the meetings between the parties, decide any issue of procedure that arises in the course of the meetings, and the facilitator's rulings on procedural issues are final and binding. So it's quite an important role that a facilitator plays. And maybe the question is, what is the process if no facilitator has been appointed? In that case, the parties must still consult for a minimum period of 60 days before any notice of termination can be issued. Prior to issuing any notice of termination, the parties must refer the dispute to the CCMA. This can only be done after a period of 30 days from the date of issuing a notice in terms of Section 189, subsection 3. Now, I will now move on to the next slide. And the question that arises, particularly in the context of COVID-19, is specifically the following. When is the employer allowed to introduce voluntary severance packages? 2, if an employer cannot afford to pay employees on a month-to-month basis, what can it do, particularly to avoid retrenchments? And what if an employer cannot afford to pay severance packages, even post the consultation or facilitation process? So those are the questions that have arisen out of the cases that we refer to in the next coming slides. Moving on to the next slide. Now we start by looking at the Telkom judgment. This case dealt with the situation of an employer who introduced a voluntary severance package before a consultation process in terms of Section 189, subsection 3. So what happened, the employer invited the union to consult on the voluntary severance package process. The union became obstructive, and its main concern was that it could not consult without first having sight of the new proposed structure. Basically, according to the union, the employer had not even shared the proposed new structure with the employees, and by extension, they did not know who was affected and who was not affected in terms of the proposed structure. So their argument was primarily that the introduction of the VSP was premature. The case was referred, the issue was referred to the Labour Court, and the Labour Court held, if I may just move to that slide, the telecom slide, slide number 7. Slide number 7. Slide number 7. Yeah, the Labour Court held that even if a party has reservations about whether there is a need for retrenchments, it must be prepared to engage in consultations on alternatives. Nothing prevents a party from engaging on a provisional basis by making it clear upfront that its consent to the adoption of certain alternative measures is subject to it being persuaded that retrenchments will otherwise be required. So it was quite a forward-looking approach by the Labour Court. Essentially, the court held that there was nothing untoward with the employer's conduct. And this case now means that the employer may offer voluntary severance packages even before initiating a process in terms of Section 189, subsection 3. Now, if we look at now slide number 8, we now deal with the question, what if the employer had already fallen on hard times and cannot pay salaries as and when they arrive? Or whilst the facilitation process is pending, the 60-day process is pending, the employer finds themselves in a situation where they cannot afford to pay salaries. Well, to answer this question, I think the SAA judgment assists in this regard. In that particular judgment, the employer introduced a voluntary severance package, a voluntary separation agreement, during a business rescue proceeding. The court was called to decide on the wisdom of the employer to initiate the voluntary separation agreements in the process of a business rescue proceedings. It is important to note that the company at that particular stage had placed a moratorium on retrenchments. And the question was, will such voluntary retrenchments packages not constitute a dismissal in light of the fact that the company had placed a moratorium on retrenchments? The court in the SAA judgment held that, said that there is no basis to argue that an employer cannot initiate a voluntary retrenchment process if there is a moratorium on retrenchment. And the court held that the approach or the argument of the union in that particular case was not supported by the Labour Relations Act, and nor was it supported by the Companies Act. The court said further that if the parties reach an agreement to terminate the employment relationship, that will constitute an agreement and it will not constitute a dismissal. This therefore extends the possibilities of employers if a company falls on hard times. Voluntary severance packages may be concluded even before a retrenchment is contemplated or a Section 189 process is initiated. Now moving on to the next slide, slide number 10, and dealing with the question of severance pay, where what happens if an employer cannot afford to pay a severance pay? Well, the sad reality is that the payment of a severance pay is a legal obligation. And this comes from the Basic Conditions of Employment Act. However, if an employer is unable to do so, the employer may apply to the Minister of Labour for an exemption. In the absence of that particular exemption, the employer is unfortunately required to pay severance pay. I will now hand over to my colleague who will then be dealing with the next aspect of the presentation, Hugo Pienaar.
Thank you. Thabang, it's going to be Gillian.
Oh, Gillian, apologies. Sorry,
But I
Gillian.
think we just have two questions. The first one is, will the reason code 17 reduce work time be available going forward? And I think Hugo will answer that, as well as how do you go about appointing a facilitator? Thank you, Hugo.
Thank you. Question. Well, in terms of going forward, I think everybody is guessing which direction it will take, but in terms of reduced time or not. We know that in terms of the current system, there were options available and you were covered in terms of reduced time or not. In future, and I'll touch on that, the question is, how will you deal with reduced time, either as alternative to retrenchment, and obviously depending on whether there's a bargaining council agreement dealing with a particular issue. And depending on how you phrase it, that will determine to what extent you may or may not have a claim for UIF.
And then the other one, Hugo, while you're online, is that how do you go about appointing a facilitator? And if you can just talk about the CCMA facilitator as well as the appointment of a private facilitator while you're online. Thank you.
Right. To appoint a facilitator, the employer falls in what you call a 7.20, 7.20 form, which you fill in and you send to the CCMA, to the other parties and the CCMA, and you attach there to your 189.3 notes. Assist the CCMA, and you must do so within, I think, 7 days. If you've not done so, any of the other parties to the process may, of course, appoint a facilitator. And then, of course, you can privately agree to do so.
And the important thing is that insofar as there is no agreement, you are unable to appoint a private facilitator. And if there is an agreement to appoint a private facilitator, they would still have the rights, or you would have the rights as if it went through a CCMA facilitator. The law, the jury is out at the moment as to whether it is better to go through the CCMA from an availability perspective, alternatively go through a private facilitation process. Let me stop there before we start taking more questions and go to my colleague, Gillian Lumb, who's now going to talk to you about the most exciting topic called selection criteria. As a matter of interest, if one scans the law reports, out of every 10 cases that comes to the Labour Court, and this is not out of any sort of mathematical statistical analysis, but our definitive impression is cases are lost in the majority of cases as a result of the implementation of the selection criteria. So, Gillian, thank you.
Thank you, Adil. Yes, as Adil said, it's certainly one of the aspects where employers are frequently tripped up at the CCMA. They go to pains of ensuring that they've got an adequate operational requirement that's valid, and they present that, and also making sure that they follow the correct consultation process, but are frequently tripped up when it comes to selection criteria and the application of those selection criteria. So what I want to do is briefly look at the provisions of section 189 subsection 7, what it provides for in relation to selection criteria, and then looking at 5 cases and the selection criteria used, which are potentially somewhat more controversial selection criteria, and how the courts have addressed those. So the first case I want to look at, if we can just move to the first slide, please. The first case is a decision of the Labour Court in which the importance of the selection criteria was highlighted by the judge. This is a decision where poor performance was used by the employer to select employees for retrenchment. There were 2 employees who challenged the fairness of their dismissals. They challenged, in fact, every aspect of their dismissals. They challenged whether there was a valid operational requirement, whether they had started, the employer had started the consultation process when it first contemplated retrenchments, whether they'd been given adequate disclosure of information, and whether the employer had considered alternatives. None of those challenges succeeded, and the only challenge that succeeded was on the selection criteria. The 2 employees were selected based on alleged poor performance, and what they said was they were satisfied that performance was used, but they weren't satisfied with the way in which those performance criteria and assessment was implemented by the employer. And what the court said was that using poor performance is problematic, and that if an employer is going to use poor performance, the employer must be extremely careful in the way in which it implements that criteria and uses that criteria, even if the criteria has been agreed with the employees that they're consulting with. And in this instance, the court found that the employees were dismissed because 2 of their managers has assessed them as being poor performers, when in fact the employees had never been subjected to a performance management process. And that in this instance, what should have happened is the employee should have been given the opportunity to make representations about their scoring and their low scoring on performance before that was then simply implemented. The dismissals were found to be procedurally unfair, and the employees were compensated in the maximum amount equivalent to 12 months' salary. So an indication there of how significant selection criteria are and how important it is to carefully consider that before you go into a retrenchment exercise. Then I just want to look briefly at what does the law say, or the section of the legislation say, about selection criteria. This is section 189.7, subsection 7 of the legislation. If we can just move to the next slide, please. The first instance, and the priority is given to agreeing selection criteria with the employees or with the trade union concerned. But even where you are able to agree those selection criteria, you still need to ensure as the employer that those criteria are not in breach of fundamental rights. And in terms of the Code of Good Practice on dismissal based on operational requirements, if you're using criteria that are agreed and they breach a fundamental right, they will constitute unacceptable criteria. Examples that they give in the code are pregnancy and union representation, union membership. As we all know, unions typically advocate LIFO, lasting first out, as the most fair and objective criteria, but that is certainly not the criteria that is always favoured by by employers. And I want to now look at some of the case law dealing with, as I said, some of the more controversial selection criteria. If we can move to the next slide, please. And the questions that we're posing then in relation to those cases are, firstly, whether you can use poor performance as a selection criteria, whether you can use affirmative action, and whether you can use past misconduct. The first decision in relation to performance is that of the Labour Appeal Court involving SA Breweries and Lowe. Lowe was an area or sales manager. His position was made redundant, and he was given the opportunity to apply for a more senior position, which was newly created, which acquired some of the positions or the roles and responsibilities that he'd had when his position was made redundant, and also more managerial roles. So it was a new position that was created after his position was made redundant, but it was a more senior position. He was given the opportunity to apply for that position and was unsuccessful in his application. He then challenged his failure to be appointed and the selection criteria on the basis of that they were unfair, and it was based on his performance rating, a past performance rating. And what was important here was what the court considered, that when a position becomes redundant, it doesn't necessarily mean that the individual is going to be retrenched. So their position falls away, but the employer then has the obligation to look for alternative positions within the workplace. And if they can't be placed elsewhere in the business, then they may be retrenched. So they're not automatically going to be retrenched. The court also sounded a warning in relation to where someone is the only person whose position is made redundant. So they're the only affected individual. It doesn't necessarily trigger selection criteria. And in this instance, when the employee was given the opportunity to apply for the newly created position, That wasn't a case of selection criteria then that they were looking at. The performance rating and the assessment of past performance was actually subjecting the employee to a competitive selection process. So what the court decided then was it wasn't unfair selection criteria. The employee was simply subjected to a selection process for appointment to a new position, and the retrenchment was a fair retrenchment. And what really happened was, in this instance, was an incorrect labelling of selection criteria when it was simply a selection process for a newly created position. If we can then move to the next judgment, please. This is a decision where there was a combination of criteria used. It's a decision of the Labour Court, NUMSA versus Columbus Stainless. In this judgment, the court was looking at a retrenchment of 220 permanent employees. The employer was facing weak demand for its product, low prices and significant cost pressures, something that many employers are experiencing at the moment. The employer consulted with 2 trade unions, Solidarity and NUMSA. It wasn't able to reach agreement on the selection criteria with NUMSA. It was able to reach agreement on the selection criteria with Solidarity. The criteria the employer had proposed were a multi-rating selection criteria of performance, qualifications, years of service, and direct supervisor review. The criteria that were agreed with Solidarity were best performance assessment, second best performance assessment, qualifications, years of service, discipline, teamwork, initiative, and flexibility. And those were all variously rated. And there were some important findings of Judge Van Niekerk in this judgment. He stated that and confirmed that LIFO is not the only fair and objective criteria that are endorsed by our courts, and that there are many decisions in which the court has considered experience, competency, efficiency, special skills, key skills retention, continued service delivery to clients, qualifications and experience as acceptable selection criteria. But what an employer needs to do when it implements criteria along those lines is ensure that it's not crossing the divide or the line between a dismissal for poor performance and misconduct and a no-fault dismissal based on the employer's operational requirements. So an important distinction to draw, and you mustn't, when it's a no-fault dismissal, slip into a dismissal based on misconduct or poor work performance. In this particular instance, the court found that past performance assessment was a fair criteria to use and that it had been fairly implemented in this instance. All the employees had been assessed in the same manner. They'd all had individual assessments. They'd all had the opportunity to raise objections and concerns, and none of them had done so. In addition, when it looked at all of the criteria, that the multifaceted criteria they were measured against, there was a panel of people that were assessing that. There was a moderator. There were scores that the employees could all give their input in relation to. And if any employee was dissatisfied with their rating, they were given the opportunity to appeal against that. So in those circumstances, the court found that the selection criteria were fair, they were objective, and they were fairly and consistently implemented by the employer. The next decision involves the application of misconduct, or past misconduct, as a selection criteria. In this matter, Premier Foods had been subjected to a very violent strike action at its workplace, in relation to which many employees had been threatened. There were many employees who were still working, and the employer had sought to take disciplinary action against those employees who were involved in the violence and intimidation during the course of the strike. Unfortunately for the employer, none of the employees who'd been witness to the violence were willing to come forward and testify. Their lives had been threatened. One of the witnesses, in fact, disappeared, so they weren't prepared to come and give evidence. So the employer couldn't proceed by way of disciplinary action and ultimately retrenched employees. It made the selection based on past misconduct, the misconduct involved in during the course of the strike action. And the court said, in principle, and this is the Labour Appeal Court, in principle, it's permissible to use the past misconduct. However, in this instance, it was clear that the employer needed to be very cautious about how it used that, because ultimately the employer failed to show that it implemented those criteria, or that criteria, fairly, objectively and consistently in this instance, because the employer was not able to show that the employee had, in fact, the employees who were dismissed were in fact guilty of misconduct, that had been involved in misconduct. None of the people who had witnessed the misconduct were willing to come give testimony during the course of the proceedings at the Labour Court, so there was no direct evidence that they'd been involved in misconduct. And on that basis, the employees were in fact reinstated with back pay. The final decision that I wanted to look at was involving Robinson versus Price Waterhouse, as a decision of the Labour Court, in which the court looked at affirmative action as a selection criteria. The 3 employees who were retrenched were a branch manager and 2 accountants. They were selected for retrenchment. One of the bases on which they were selected was that they were the highest earners. The employer needed to save costs, and it decided to select those individuals because they earned at the top of the rung. The employees were ultimately presented with a fait accompli. They were selected on that basis. There was no engagement with them on the selection criteria, and they were simply dismissed as the highest earners. And that was found by the court to be unfair. In addition, the employer had sought to argue that it had selected one of the employees for retrenchment on the basis that their retrenchment benefited the employer's affirmative action policy. And the court stated in that regard that affirmative action is not and never has been a legitimate ground for retrenchment. And in fact, this instance, the employer couldn't succeed in that argument in any event because the employee who was ultimately retrenched, the one that they were referring to, was an Indian woman. So it wasn't possibly advancing their affirmative action policy. Then finally, I wanted to deal with the issue of bumping, which I think we need to accept is something that may arise more and more in the retrenchment exercises that you may be embarking upon at this stage. Very often, employers will make the assumption that employees who are being retrenched will not want to look at potential horizontal bumping, where they may have to move to a lower position, lower in status, and a decreased salary, and that they won't then look at bumping or won't need to consider that. What we need to accept in the current climate, with many employees potentially facing challenges in finding new employment, that they may well be prepared to accept the horizontal bumping. Thank you very much. If I can then hand over to Hugo.
I think Hugo, just let's see. I think they may there may be just an issue with something here. So let's let me start on this before Hugo joins us. Firstly, my name is not Professor Hugo Pienaar. I am no professor. I'm just a mere lawyer. So this is probably the most controversial aspect of retrenchments. Can you change an employee's terms and conditions of employment, or can you retrench an employee because they refuse to agree to a change to their terms and conditions of employment? We start off before the amendment came into being, and the courts have held that you may do so, without getting into the legality, that you may do so provided those dismissals are final in effect. We come back to a situation which says what would happen. So the amendment comes into being, and what would happen insofar as we want to now retrench employees because they refuse to accept a change to their terms and conditions of employment in the year 2020. Initially, our courts held that you cannot do so. And we'll go through practically how that operated. It goes all the way to the highest courts, and eventually the courts held that you may do so. So you may retrench employees because they refuse to accept a change to the terms and conditions of employment, provided it is final and you can satisfy the test for retrenchment. So the question is, we've come a full circle despite the amendment. But that, I gather, is not what you are interested in. What you are interested in is how best do you ensure that you are not met with unsuccessful litigation insofar as you wish to change an employee's terms and conditions of employment. So let's start off with the basics. 1, before you wish to change any employee's terms and conditions of employment, you must obtain that employee's consent. Alternatively, if you don't have the employee's consent, and if you have a trade union, you conclude the agreement with the majority trade union and then extend that agreement to all your employees who are non-union members or union members of a minority trade union. Your next option is, if you do not want to embark on the retrenchment process, is to inform your employees, these are my terms and conditions of employment if there's no agreement, and I will lock you out until such time as you accept my change to terms and conditions of employment. And because what is colloquially called as an offensive lockout, you are unable to appoint any temporary labor, and therefore, as they say, you're cutting your nose to spite your face, because you are unable to render services while your employees are outside. So now you have a dilemma. You cannot obtain employees' agreement. You don't wish to lock them out. What do you do? So the question then is, you start off by undertaking the following. You go to your employees or the trade union and you say, I wish to change your terms and conditions of employment. And those employees indicate to you that they are unable or they refuse to do so. You then issue a section 189(3) notice, and because there will be a large-scale retrenchment, you'll decide either, you'll have one of 3 options, as Thabang has indicated: appoint a facilitator, do not appoint a facilitator, or go through private facilitation. And your reason, your business case is that my current terms and conditions of employment are too expensive, and as a result of that, I have an economic need. And you must be able to show, amongst others, that the cost of your change of your terms and conditions of employment before and after you are going to save money. Alternatively, you must be able to show that structurally what is the reasons for you wanting to change your terms and conditions of employment. And this arises particularly within the context of a section 197 transfer. Within a section 197 transfer. And with that interesting thing, I am going to now hand over to the real professor, who will take us through his slide while I was standing in and elucidate on this challenging topic and tell us how to navigate it. Thank you.
Thank you. It looks as if I might be back. So let's just see, give me 1 second there. I've moved to a different room and I think I'm back.
Hugo, please unmute.
Right. Thank you. Thank you for waiting on me. So the topic that I am addressing is this whole debate whether I can unilaterally change conditions of employment by using or sometimes abusing a 189 process. In other words, I issue a 189.3 notice with the sole purpose of reducing wages and conditions of employment. Now, let's just take it back one step and to see where this dispute started. And it's really the difference between a dispute of right and a dispute of interest. Now, we know a dispute of right is where you have a third party intervening. It's a typical unfair dismissal dispute, and you have a third party intervening and the third party adjudicates. A dispute of interest is the typical wage dispute. I want to increase wages, I want to reduce wages. That typically falls within the ambit of a power play or a dispute of interest. And what will then happen is that you will refer the dispute and ultimately you will have a lockout or a strike in order to force the other party to agree to your proposal or demand. So that is the two main differences, and of course the question is to what extent is there a way of interlinking the two and cross-purpose, and I'll come back to that. But of course the difficulty is, let's assume the COVID scenario is, yes, the employer, I've lost a significant income during this period of time, revenue, and I can't continue working. And in terms of the power play scenario, my only option would then be to lock out my employees. If I lock out my employees, it means that it's an offensive lockout. I can't bring in replacement labor, and that would amount to stupidity. Now, we know that's one of the diseases we're fighting at the moment in our country, is the one of the stupidity, but certainly this can't be correct, and this can't allow an employer to survive when there are other tools available. So the question really is, can I move from a dispute of interest to a dispute of right, in other words, using the retrenchment arena? Now, if we look at the legislation and we look at the definition of ETSOS, of operational requirements, it says, what can you retrench? You can retrench for operational reasons, and how is that defined? We generally say economical, technological, or structural arrangements or reasons. Now, the interesting thing when you look at this, the underlying concept here is still a unilateral change of conditions of employment. Because if you look at, I'm going to retrench you, you have a contract of employment, you've been in my employment, and the contract says that you retire at the age of 60 or 65 or 70, and now I want to retrench you. In other words, by using a retrenchment, I'm effectively changing your condition of employment. And the same really applies when I combine positions, when I redefine positions. I take your original position, I'm giving you an alternative position as an alternative through the retrenchment, and effectively changing your conditions of employment. And in fact, when you get to bumping and people bump people one level below, you'll find that even there's a unilateral change coupled with the reduction of wages. So yes, an operational requirement is effectively a unilateral change of conditions of employment, and we know that case law says you can even retrench if the company wants to make more profit. But of course, we also know after the Woolworths judgment, we must be cautious about that. So let's just move to other sections of the Act where it deals with this interplay between a collective power play dispute of right and a dispute of interest. Now, We know that if we look at section 187, 1C of the Act, it says, can we please move to the next slide? 187, 1C says that you can't dismiss for an employee refusing to accept a matter in respect of a matter of mutual interest. And of course, without going into the detail, it was about outlawing the 1956 Act's approach to the so-called lockout dismissal. Don't have time to go into that debate at the moment, but let's look at some other sections also providing for this. If you look at section 67.5, that in fact says this is now a strike, it's a protected strike, but it essentially allows you that you can even retrench under those circumstances. So you have a power play, you have a dispute of interest, but this section allows you to move into a dispute of right and effectively retrench people for genuine operational requirements. Of course, it's not only under 67.5 where you find it, but section 188 is quite specific, where it says a fair form of termination of employment is a 189, in other words, a retrenchment based on operational requirements, and provided the employer complies with substance and procedure, that's a fair form of dismissal. The interesting thing is, of course, in this interplay, you also have matters that automatically or historically fall within a dispute of right arena that can also move into a dispute of interest arena. And a typical one would be a large-scale retrenchment. You will recall in terms of a large-scale retrenchment, once you give notice of termination, the employers have a choice to either refer it to the Labour Court on substance or go on strike. So you move into the power play arena. Similar section 12 to 15 or 16, the organisational rights disputes. Employers have a choice to have it adjudicated within the ambit of a dispute of right or have it dealt with under a dispute of interest, in other words, elect to strike on it. So let's just briefly look at some case law and then try and answer the question. Now, the Avenge case was the first, not the first one, was a case decided under the previous 187 amendment. In other words, before it was amended, 187 was amended in 2015, and in Fry Metals, of course, the employees had a few demands. The employer had a few demands and wanted to. Can we move to the next slide, please? Where the employer had a demand and he said, "I'm going to retrench you until you accept my proposal." And the one was about a shift arrangement, and the other one was about removal of a transport subsidy. And in that particular case, the court said that you may use, in fact, it does not prevent employers from dismissing employees on operational grounds who do not accept proposals and amendment to conditions of employment. In such gave the go-ahead for a retrenchment despite the provision of 187(1)(c). Now, the more important case for the moment is, of course, the Avenge case. And we know in terms of the Avenge case, what has happened is that this is a matter that has gone to the Labour Court and the Labour Appeal Court and is currently pending before the Constitutional Court. But it deals with this interplay where the employer used a retrenchment and the union said you can't do that. 187(1)(c) prevents you because you can only change conditions of employment via a power play, in other words, a dismissal, a strike or a lockout. So let's look what happened briefly in Avenge. What the employer considered was dismissals for operational reasons. They needed to reduce costs to remain profitable. They had to restructure, realign, improve productivity and all of that. And what did they have to do? They had to redefine certain job descriptions, mothball certain equipment, reduce the limited duration contracts, and reduce transport benefits. Now, don't have time to read, to go into the merits of the matter, apart from saying that there was an interim arrangement. The unions reneged on that. It was NUMSA, and ultimately the employer said, enough is enough. I've been consulting now for two years almost. I'm now going to unilaterally impose this, and what I'm going to do is, here's the new redefined jobs. This is the offer to the employees. Either you accept it. If you don't accept it, then you will be retrenched. and in that process 700 odd people lost their jobs, 30 odd people accepted the alternative offer and retained their jobs. And the Labour Appeal Court said that you may do so. And if we look at some extracts from that, before we look at a typical scenario on the next few slides, just going to run through that very quickly because you're going to receive these slides. Can we please move? All right. Must maybe move. So what did the court say? The court said to alter job description was an appropriate measure. Why? To avoid minimizing dismissals. And if that's the only viable answer, of course you can restructure and you can redesign, and you do that. Why do we do it? To prevent retrenchments. And that's always the starting point here. Can't start with negotiating wages and conditions of employment. You simply want to reduce wages. It doesn't work, and now you revert to a 189 process. You can't do that. And the court in this case, can we go back to the previous slide? So the court in this case made it clear that it is an option to revert to a 189.3 process. I don't know why we can't just go to the previous slide. All right, we're not going to do that for some reason. So let me go to the practical solution and scenario here. So this is the case. You now have had COVID. You're in the auto manufacturing industry. You need to retrench 10% of your workforce, but you still need 2 people on an assembly line, by way of example. So I can reduce my workforce by 10%, but I still need 2 people on the assembly line, and I still do not make a profit. So can I now go into a retrenchment and at the same time reduce my wages? And the answer is effectively yes, provided it's a genuine operational requirement. So you go into the retrenchment process. Part of it is to reduce numbers and to limit the extent of the retrenchment. In other words, I'll reduce it to only 10% of the workforce, but that's not enough. I'm still not profitable, and I now need to reduce pay by another 10%. And of course, that is possible within the framework of this judgment. The difference is, of course, in the bench case, the employer offered the employees the option of opting for the retrenchment or not. In the auto manufacturing industry, you're not going to have that option because you need to retain 80% of your workforce. So the question that the court does not answer that is I'm now not going to offer you the alternative. I've laid off 10% of my workforce, and for the remainder of the workforce, I'm going to unilaterally implement a 10% wage reduction. And in fact, I'm not going to offer you retrenchment because I'm not going to offer you severance pay because 10% is a reasonable alternative offer. And that's the questions, those questions we still need an answer from, but we do know at the moment in terms of a bench, you can make an offer and it may be in a reduced offer, and if the employee does not accept, then you can retrench and you can reduce. What the court has not said, and I'm repeating that, the court has not said if I can unilaterally introduce and reduce the reduced pay, and I think the sensible answer would be yes, of course you can. Is 10% a reasonable alternative offer? In other words, you won't qualify for severance pay, and my sense is yes, it may be, because you look at 4 factors for an alternative offer. You look at is it pay more or less the same, the remuneration, what about status, what about job security and personal circumstances. And it may be an argument to make out, given the high rate of unemployment, given the status of the company, 10% is in fact a reasonable alternative offer. So in short, if we look at the judgment, the bench case gives us the go-ahead. We've been in the matter in the Constitutional Court. Our sense at this stage is that it will follow the decision of the LAC. In other words, allow employers to utilize 189 to change conditions of employment. May it be a unilateral change by way of offer, Of course it can. Maybe a unilateral change without an offer, that question needs to be answered. And the question of severance pay is still up for grabs by some brave employer. This is the best we can do in 15 minutes. Thank you for your time.
Thank you, Hugo. That was most informative. Those colleagues and clients that have sent us questions to the best of our ability, and given the time period, I've responded privately to each of your questions. What we are doing in order to guide you, and that's through Riola, we will be, in addition to releasing the electronic recording of this session and the slides, we've developed an easy guide to retrenchments, which will be emailed to you within the next day or so. As is customary with us, we try not to have too many words because there's enough reading material out there. So it's by way of pictures and diagrams and a question and answer session. Once again, we'd like to thank you for the support that you've provided to us. We hope that you and your family are safe and healthy, and that any challenges that you are embarking upon, you do so in a fair and equitable manner. And finally, we've taken over from Gillian as the epicenter. Gillian is in the Western Cape as the epicenter of the COVID-19 pandemic. Thank you one and all for joining us. Good afternoon and goodbye till next time. Thank you.